So it's 3 p.m. I'd like to call this meeting of the City of Clearwater Nuisance Abatement Board to order. First item on the agenda is the approval of minutes from the last meeting, June 5th, 2019. Would anyone like to move to approve the meeting minutes?
Gary Baker, I move that we approve the minutes of the June 5th, 2019 Nuisance Abatement Board meeting as submitted in writing by the city clerk.
Thank you. Do we have a second?
I'll second that.
Okay. All in favor? Sorry. Any nays? No. The meetings have been, or the meeting minutes from June 5th have been approved. Sorry.
That's okay. So we have item 3 just 3, citizens to be heard regarding items not on the agenda. If anybody is here that is to discuss something that's not on the agenda, you may approach the podium. Okay, back to you.
Okay. On this one, new business items are next on the agenda. 4.1 is to elect the chair and the vice chair of the committee. Do I need to recuse myself from this one?
No, and so I'll just remind you that pursuant to your rules of procedure that you have adopted under Roman numeral number 4, nomination of officers shall be made from the members at the annual organizational meeting, and the election shall be held immediately thereafter. That's this meeting. The candidate receiving a majority of the votes cast shall be declared and elected and shall serve for a term of 1 year or until a successor shall take office. The chairperson may not serve more than 2 concurrent terms as chairperson. Those are your rules under election of officers. There would be a nomination from the floor, one of the members. And we'll address the chairperson first, and then we'll address the vice chair.
Okay. Does anyone move to nominate a chair?
We did that. Yes, I nominated you, didn't I? I thought so.
Yes, you did.
Okay.
Okay.
I move to keep that valid.
I second.
Okay.
Are there any other nominations for chair? There being no other nominations for chair, you are now the chair. There's no vote necessary to take since there's no other nominations. And we can move to the vice chair person now. We do it the same way. Nomination from the floor.
I'd like to move Ms. Olivito, correct? No.
No,
Lane.
I nominated her last time.
We did, and she's gone. No, where'd she go?
No, she's here. She's just not here today.
She's
but
here,
she's
just
still on
not
the board,
here
yes.
today. Okay, I'm sorry. I'd like to move to continue her as vice chair.
A second.
Are there any other nominations for vice chair? There being no other nominations for vice chair, then Ms. Oliveto will be the vice chair for the next year or until her seat is filled by some other method. So now we can go ahead and move right to item number 2, case number 2020-01, City versus Wendy S. Solomon, and the city would present first.
Thank you, members of the board. My name is Matt Smith. I'm a senior assistant city attorney for the city of Clearwater, and I will present the case today. I have a few witnesses. I'm going to present a narcotics sergeant, and they're going to explain how this property came to be on their radar and the steps that they took. I'm going to present a lieutenant who's going to explain what she did to try and mitigate the issues that were at the property. And then you're going to hear from the actual narcotics detective who conducted the undercover work that is itemized in the complaint. And as you see in the complaint, there are three charges, 3 cases. And pursuant to Clearwater local ordinance and the state of Florida statute, what I have to prove today is that there were, for this particular case, I have to prove that there were 3 narcotics transactions within a 6-month period, and those narcotics transactions have to have been a felony. And with that, I will go ahead and delay no further and call the first witness, who is going to be the narcotics sergeant. And just a word to the board, so the narcotics personnel, the narcotics sergeant and the detective, they're undercover personnel, and so they are going to testify from a remote location. And you might see their silhouette and you will hear their voice, but their voice has been heavily disguised so that their anonymity and undercover status keeps intact. And so with that, I'm going to call the narcotics sergeant. Sergeant, are you there?
Yes, sir, I'm here.
Madam Chair, we need to go ahead and swear in this witness.
You stand and raise your right hand. Do you affirm to tell the truth, the entire truth, throughout your entire testimony?
I do.
Thank you, Sergeant. Can you please state your title?
I'm a police sergeant with the Clearwater Police Department's Vice and Narcotics Unit.
And how long have you been so employed?
I've been with the Clearwater Police Department since 2009, and I've been the narcotics sergeant since 2019.
And in your capacity as a narcotics sergeant, do you have any specialized training or experience?
Yes, sir. I've attended the 2-week DEA basic investigator course, as well as a multi-jurisdictional drug interdiction course, undercover surveillance operations, wiretapping, and other electronic surveillance courses.
Thank you. And can you please describe your role in the Clearwater Police Department's approach and procedure to nuisance properties?
Yes, sir. Generally, the way it happens is the activity, in this case, narcotics activity, comes to our attention. Determination is made at that point whether or not the activity fits within the ordinance and the statute definitions. At that point, we then make narcotics cases from the location, and that package, once completed, is referred to the legal office for review. At that point, legal then refers it to the chief of police, and then the chief authorizes a letter to the owner or the operator to meet with the district lieutenant.
Okay. And specifically, what is your role in addressing nuisance properties?
My specific role is to supervise the vice and narcotics detectives within the unit who are conducting controlled buys or purchases of narcotics from these locations.
Okay, so you supervise the actual undercover detectives who conduct the activity that's outlined in the complaint?
Yes, sir.
Thank you. Are you familiar with the property located at 1576 South Washington Avenue?
Yes, sir, I am.
And that's in Clearwater, Florida?
Yes.
And how are you familiar with that property?
This property has been an issue for some time to residents in the neighborhood due to ongoing narcotics activity. It came to my attention specifically on June 20th of last year when we conducted our first narcotics purchase from the location.
Okay. And how specifically did the property come to your attention in a nuisance capacity?
I was notified by one of my detectives that we had a confidential informant who identified this location as selling drugs. It was also brought to my attention by the district lieutenant that there had been multiple complaints, and she asked that we attempt to conduct any controlled buys if we have any informants capable of doing so.
Could you briefly summarize or describe the activities and the issues that were noticed at the property?
Sure. It was brought to my attention that there were large crowds, also loud music playing, and frequent visitors to the property that were believed to be purchasing narcotics from several subjects at this location.
Thank you. Now, in the complaint, there are three separate investigations, June 20th, June 28th, and July 9th of 2019. Were you asked to prepare a statement of costs associated with the investigation the investigation of the property?
Yes, sir.
And what was the total cost to the department for investigating the property on those 3 dates?
The total cost was $823.22. The complaint lists 3 drug-related investigations that were conducted by members of my unit. The investigations associated with those 3 investigations was determined to be that amount. That includes personnel, evidence, submission, and narcotics purchase costs.
Thank you. Sergeant, that's all the questions I have for you. Is there anything further you'd like to add?
No, sir.
I have no further questions. I don't know if the owner would like to submit a
So
question.
is the owner here? Is Wendy Solomon here? Okay, ma'am, if you could step right up here. Introduce yourself and your address, please.
I'm Wendy Humphrey, and my address is 1513 South Washington Avenue, Clearwater, Florida, 33756.
Okay, so you said Wendy Humphrey.
Yes,
Okay, is your prior name Wendy S. Sullivan?
yes, used to be.
Okay, all right. So now is your opportunity to ask this individual who's testifying. You can ask that person questions. It's what we call cross-examination. Do you have any cross-examination questions for the person, the sergeant that is testifying now? You don't have to, but this is your opportunity. Do you have any questions for him? No?
Not really.
Okay. You'll have your opportunity to speak later. This is cross-examination. Okay. All right. There being no questions, we'll move on to the next witness.
Thank you.
Thank you.
At this time, I'm going to call Lieutenant Natalia Illich-Haley. Afternoon, Lieutenant. Swear. Okay.
Raise your right hand. Do you affirm to tell the truth throughout your entire testimony?
I do.
Afternoon, Lieutenant. Could you state your name for the record?
Natalia Illich-Haley,
And what is your rank with the Clearwater Police Department?
lieutenant.
And how long have you been a lieutenant with the Clearwater Police Department?
Lieutenant for 2 years.
And before that?
I've been employed for 15 years with the agency.
And could you please describe for the board your duties as it relates to nuisance abatement?
Sure. So the detectives make cases out of a property that deem it that constituted to go before the Nuisance Abatement Board. So they will generate an email outlining the cases that qualify for this process. The detectives will send that email to Matt Smith, who will draft a letter. It'll go to our chief of police, and he will send out the certified letter to the property owner. That letter tells the property owner that they are to contact the district lieutenant. In this case, this property falls in my area of responsibility. So once the property owner contacts me, I meet with the property owner and we discuss the reasons for her property being qualified for the nuisance abatement process. And we also discuss mitigation steps of what she can do, my recommendations of what she can do so that the criminal activity will no longer continue. We make it clear that if the activity does continue, that she could be brought before the board, which is what happened with this one.
Thank you. Now, you've referenced the owner, but my next question was, are you familiar with the activities at 1576 South Washington Avenue?
Yes, I am.
And is it fair to say that the activities that took place at that property were sufficient enough to trigger the threshold to where the letter gets sent out?
Yes, they are.
Okay. Now I'm going to show, I have a few exhibits, and the exhibits were attached to the packet that the board has. The first exhibit I'm going to refer to is already in your packet as Exhibit B, but for the record, I want to submit these separately. Lieutenant Illich-Haley, I've shown you what I've marked as Exhibit number 1. Can you take a look at that document and tell me if you recognize it?
I do recognize it.
And what does it appear to be?
This is the letter for the nuisance abatement process that gets mailed to the property owner.
And you did talk briefly about the letter. Could you please, is it fair to say that the purpose of the letter is to put the owner on notice that activity has been observed at the property and that it's a problem and that it needs to be resolved?
Yes.
Okay. And then once the owner receives the letter, which is exhibit number 1, the letter directs them to contact you?
Correct. This particular letter directs them to contact Sergeant Baginski because at this time I was out of the state for a training, so he was covering for me in my absence.
Okay. Now, do you recognize this letter as being generated and kept in the normal course of business at the Clearwater Police Department?
Yes, sir.
Board, I would move to admit Exhibit 1 into evidence.
I second.
So, Ms. Solomon, do you have any objection to this being received into evidence? Is exhibit number 1. Any objection, legal objection to it being received into evidence? You'll have the opportunity to address the board in just a few minutes. We just want to deal with the documents as they come forward. So, Madam Chair, there being no objection, I would suggest that it's appropriate to receive it into evidence.
Agreed.
Thank you. Lieutenant Illich Haley, did the owner respond to the letter to exhibit number 1?
I was advised by staff in the chief's office that they did get the certified letter returned back, which means that she did receive it.
Okay. And did she reach out and contact either yourself or Sergeant Baginski?
I don't think so. I came back from the training and I met with Sergeant Baginski and he had not had any contact with this property owner, so I went out myself when I returned back and made contact with her.
Okay, so you did not receive a response to the letter, so having that be the situation, you took it upon yourself to go to the property and meet with the owner yourself?
Correct.
To initiate contact?
Correct.
Okay, and did that occur on April 4th, 2019?
Yes, it did.
Okay. If you could turn to the 3rd page of the packet that I gave you. There's a second document that's been marked as Exhibit 2. Could you take a look at that document and tell me if you recognize it?
I do.
And what does document Exhibit 2 appear to be?
This is the email that I wrote and sent to our internal group advising of my meeting with Ms. Solomon and the contents of my meeting and what we discussed.
Okay. And for the board and for the members of the audience, this is Exhibit C, which is attached to the Nuisance Abatement Board packet. Lieutenant Illich Haley, could you please briefly summarize what happened when you met with the owner on April 4th?
Sure. So I met with Ms. Solomon on April 4th, and I went over the letter and the cases that qualified it for this nuisance abatement process. I discussed the process with her. I talked about the drug activity that is listed in this letter that qualified the property. In addition to that, I had received a lot of complaints about this particular property, about noise complaints, people being in their car, having loud stereo music, just a lot of people loitering around the property. So I just kind of made it very known about, I encompassed all the issues that I've been dealing with this particular property. With that, Ms. Solomon advised that she did acknowledge at one point that she believed that the problem tenant is Mr. William Wilson. He's the renter of the property. And she did acknowledge that he was a source of a lot of these issues. So when we spoke of the issues, she downplayed some of it in the sense that, you know, the complaints from the neighbors about the kids and the loud music, those are kids, you know, just quote, as she said, just kids acting a fool. But so she would go back and forth about taking ownership of the activity happening at her property, but she was aware of the complaints. She was aware of the drug complaints at her property, and at one point she did acknowledge that Mr. Wilson, the subject that is renting from her, is basically the main cause of these issues.
Did you and the owner discuss the owner no longer renting to Mr. Wilson?
We did, so that's part of the mitigation strategy. So to me, it was very clear that if this one particular person is a problem and bringing a lot of the issues to the property, then that needs to be addressed. So we talked about what kind of lease that she has, and she told me how Mr. Wilson had been staying there for a year, but was no longer on, the lease had already expired, so she didn't have an updated lease. We spoke about the need for her to change her rental agreement to have verbiage in there that states that illegal criminal activity will lead to immediate eviction. I recommended that when she rents out to future tenants, she require that they submit some kind of proof of photo ID, and that she attach that to the leasing agreement. I also recommended that she complete background checks on future tenants. I also recommended that she add exterior lighting to her property and that she improve the outside appearance because there was a lot of trash and debris and just things accumulating that were the source of a lot of code violations in the past. So she had told me that she collects rent every month. I asked her if Mr. Wilson was paying rent, and she told me that no, he wasn't. So we also spoke about the fact that if you rent to people without an updated agreement or a valid leasing agreement, and you don't even require them to pay rent on time, we talked about the kind of clientele that's going to attract to our property.
Thank you. So this was a discussion you had back on April 4th, and you just walked through the list. There's a bullet point in your email, starting with the written rental agreement. To date, do you know whether or not she has implemented these policies? Has she implemented having written rental agreements?
I last met with her on January 9th, and at that time, the only rental agreement she could produce was from 2017. So now, as far as I know, none of this has been updated.
Okay, and along with that, you haven't seen an updated rental form from her that includes a provision about illegal criminal activity breaking the lease?
Correct, I have not seen that.
Okay. Do you know whether or not she moved to evict Mr. Wilson, who you had identified as the primary source of the illegal activity?
No, because when we last met in January, Mr. Wilson, for charges unrelated to this, is currently in jail. So that's another opportunity that I took to express to her that I strongly recommended that she take this opportunity when he's in jail to file the eviction paperwork, because she knows where he is. He can be served right in jail. And at that time of that meeting in January, it had not been done.
Okay, but to be clear, this is a meeting, in this email, this exhibit memorializes your meeting you had with her on April 4th, and you at that time discussed with her that Mr. Wilson is the source of the issues, you need to evict him, you need to, take steps to protect yourself, and she didn't do anything, and then when you check back with her in January, she still hadn't done anything, and then the problem resolved itself by him getting arrested, is that correct?
Correct, and we even from the very beginning, from the first meeting, when it was very clear that he was the problem, I flat out asked if she would evict him, and she said no. So he had told her that he would be moving out, but he had been telling her that for a while, as I understand it. So I asked her, so if he doesn't move out on his own, what are you going to do? And then there was no response to that. So I didn't believe there was ever any intent for her to evict him.
Okay. Well, going beyond what you believe her intent was, is it fair to say that there was never any action, there was never any result? Mr. Wilson was never evicted, paperwork was never filed, and the only reason he's not there today is because he was arrested for unrelated issues, correct?
Correct. I was advised on June 18th. One of the community liaison officers, Officer Frederick, has also been working with Ms. Solomon and meeting with her on a regular basis, and she did provide him at that point a letter that she advised would be an eviction notice for Mr. Wilson. It was a 3-day notice that she was giving to him with handwriting on there talking about the nuisance that he's creating, having people on the property. However, as I understand it, that was never followed through with on court. Mr. Wilson did not accept that 3-day notice eviction letter, and she, even though she advised Officer Frederick that she would be going and filing the formal eviction paperwork, that was never done.
Okay, now your second bullet point in your email, exhibit number 2, require tenants to show photographic identification, and that relates to the lease. I assume that never happened?
Correct, that did not happen.
Okay. I guess we've already talked about she does not have a written rental agreement system in place, so I assume that she doesn't conduct or complete background checks on future tenants.
Correct, as far as I know, she does not do that.
Okay. And I guess as of today's date, or at least as of January, when you last met with her, do you know whether she has a current list of her tenants? Does she know who's living there right now?
As of January, she did not. The only lease that she could provide me was one from 2017 that had Mr. Wilson's name
Okay.
on it, and she had handwritten other names on there as well, but she had stated that none of those people currently live there.
Okay. Did she add exterior lighting?
No.
Okay. And the outside appearances that you're referencing, the trash, rubbish, vehicles, parking, has any of that been addressed?
That had been. In the very beginning, she had cleaned a lot of it up significantly. There was still a lot more to do because it was quite the problem, but she did clean a lot of it up. And to the point that a couple times that our code enforcement went out there were no violations, but it started right back up again. And by the end of last year, the code enforcement advised that there were several more code violations related to that.
Okay, so is it fair to say the issues were addressed initially after your meeting and now they've come back? They've crept
That
back?
one issue was addressed.
Okay. Okay, thank you. And again, the email that we've been talking about, exhibit number 2, this is a printout of an email that you drafted and resides on the servers for the city of Clearwater, correct?
Correct.
So it's kept in the normal course of business?
Correct.
And does this email, exhibit number 2, fairly and accurately represent your thoughts and your recollection, your memorandum as of April 4th, 2019?
Yes, it does.
Thank you. And after April 4th, 2019, did you have any further meetings or discussions with the owner?
Yes, on May 7th.
Okay, and once again, the packet that I handed you and I handed the owner, if you turn the page, it's marked exhibit number 3.
Correct.
I'm sorry, let me back up. Board, I would move that you accept exhibit number 2 into evidence that we just discussed.
I'll second that, and can we call it Exhibit C?
Well, I need to find out. Ms. Alma, do you have any objection to that email of April 4th being received into evidence?
Did I get an email?
No, I'm asking you whether or not you have a legal objection as to the email dated April 4th from the lieutenant can be received into evidence. Do you have an objection to that? It's not whether or not you received it. Do you have a legal objection?
With the stuff she just said? Yes.
No, with the letter or email being received into evidence. That's the question. It's in your packet that you've been handed? Okay, can you stand up here, please, to the microphone so we can get you on?
Thank you, sir.
Thank you, appreciate it coming up. So the city has tendered into evidence exhibit number 2, which is the email from the lieutenant to police nuisance property on April 4th, 2019. Do you have a legal objection to it being received into evidence? And if so, state the legal objection you have.
I have done something whenever they came out there. In reference to what she's saying, I have done.
Okay, a legal objection would be something like it's hearsay, it's not relevant.
Some of that stuff is hearsay, and yes, when you have problems with people in our area, even the city code maybe say how people, they talk against one another, they fight against one another, they call in, sometimes stuff don't be true, sometimes it do. They call in on my house, and sometimes stuff don't even be true.
Okay.
You know what I'm saying?
So those are not,
might be true.
those are not legal objections. Do you have any legal objection you want to raise? Because we're going to need to move on through this process. If you don't have any legal objections, we're going to...
So is we not doing anything?
No, as far as this being received into evidence.
So you said, did I get that?
No, I'm asking you whether you have a legal objection to it being received into evidence.
I don't know.
Okay. So if you don't have any legal objections, it's going to be, my recommendation, Madam Chair, to receive it into evidence. There's no legal objections, and so it should be received. So Ms. Olma, could you stay closer to the front so that we can hear you when you're speaking? Yes. Thank you.
Lieutenant Haley, I believe the last question I asked you is whether or not you'd had any further follow-up meetings, and you said yes on May 7th. And so now I would direct you to turn the page to what's been marked as Exhibit 3, and for the board and members of the audience following along, that's Exhibit D, attached to the packet. Could you take a look at what's in front of you as Exhibit 3 and tell me whether or not you recognize that document?
I do.
And what does it appear to be?
This is the email that I drafted to the same internal email group advising of my meeting with her on May 7th.
Okay, so again, this is a memorialization of your meeting with the owner on May 7th, 2019, correct?
Correct.
Could you please briefly summarize what you said to her and what she said to you?
Sure, so we just went over again what steps were being taken or what the status is of the property. She stated that she still does not have a written lease in place, that Mr. Wilson is still living there. I asked her if what the delay was in not updating the lease, and she stated that she's still trying to work out the verbiage of the rules to put in there. While I was speaking to her, Mr. Wilson did show up at the property where we were speaking, and we just spoke about the same things, how my recommendation that she collect rent on a monthly basis, on a consistent basis. She did state that Mr. Wilson had paid her rent this week, but it was not on a consistent monthly basis. So we just reiterated what was done, what was discussed the previous month.
So is it fair to say that on May 7th, you reiterated the recommendations that were made before, and you had still not seen any progress on the recommendations made?
Correct.
Okay. So after May 7th, you know what, scratch that. I would move that the board accept exhibit number 3 into evidence.
Okay, Ms. Hallman, again, this is exhibit number 3 that's being offered into evidence. Do you have any legal objections to it being received? Okay. It would be my advice to either accept exhibit number 3 into evidence. And Mr. Smith, we only had the first one, so do you want to have exhibits 2 and 3 presented? You only have one exhibit over here so far. Do you have the originals that you want to submit?
Oh, the originals are in the lieutenant's hand, so we'll give those to the clerk when we're done looking at them.
Okay.
That's okay.
All in favor of receiving exhibit?
That's your decision, Madam Chair.
Right,
It's not
that's
the
my
board's,
decision.
yours.
Perfect. We will receive it into evidence.
Thank you.
So, Lieutenant Illich Haley, as of May 7th, did you feel that the owner had a clear expectation and understanding, a clear understanding of your expectations as to what needed to be done, what could be done at the property to mitigate the issues?
Yes.
But as we've discussed, despite that clear understanding, nothing was done. With the exception of some of the code enforcement issues, trash and debris.
Correct. Some
Okay.
of those were addressed, but to me, the pressing issue obviously was the problem tenant that was there, and that nothing was done towards that.
Right, and to be clear, what we're talking about is the narcotics. The suggestions to correct the narcotics activity, those did not happen.
Correct.
And the narcotics activity did not abate.
Correct.
Okay. Now, we've been talking, and you did mention that you came out in January of this year, correct?
Correct.
And that's the last time that you met with the owner?
Yes, that's the last time I met with her.
Okay. And at that time, there was a discussion about Mr. Wilson being arrested?
She had already been aware of that from, I believe, by Officer Frederick.
Okay. But to be clear, in January of this year, none of the things we've been talking about had been done except for some of the code enforcement issues, trash and debris.
Correct.
Okay. Now, since January of this year, do you know whether or not there have been additional narcotics activity at the property?
Since January of this year?
Yes.
No, I do not know that.
Okay. And do you know whether or not any of the things discussed have been implemented yet?
No, as of our last meeting in January, they had not.
Okay, she hasn't reached out to you?
No.
Okay. Lieutenant, do you have anything further to add? Anything I missed?
Sir.
Okay. I don't have any further questions for the lieutenant.
Ms. Humphrey, now is your opportunity to ask cross-examination questions of the lieutenant. Do you have any questions for the lieutenant?
Yes.
Okay, if you could step forward to the microphone. Understand that both of you are going to be in front of that microphone there. Ask your questions. Don't make any statements. Just ask your questions of the lieutenant.
Is it not true? I just seen this on TV. I don't know what I'm doing, but I think this is right.
Clerk.
Is it not true that I ain't do nothing when you came and stated whatever you said to avoid trying to get things together?
Excuse me, has the owner been sworn in?
She's not testifying. She's cross-examining.
Okay.
Okay. Lieutenant, did you understand the question?
The question I heard is it true that you haven't done anything, if that's what I'm saying? Is that correct?
Yes.
I acknowledge that you did do things. You did things in regards to the code violations and the exterior of the property, the cleaning up the debris. But the main issue of dealing with the tenant that you acknowledged was the issue, Mr. Wilson, none of those suggestions were adhered to, or you didn't really care. It didn't put much importance in it. You know, he said he was going to move on his own, but if he didn't move out, you weren't willing to evict him. So that wasn't addressed. The issues with the paperwork, having a lease agreement that's valid and current, that was never addressed. Mr. Wilson was never required to submit an updated new rental lease agreement. So the one thing that you did do was clean up the outside of the property.
Okay. Was you not told that the eviction was in process? That was doing when you came the first time? Was when you said you came late? So I got to look at the date because I didn't know this was going to be like this. You can look in the records and see that I did do an eviction. And at the end, it went all the way through to the end where they processed everything. And I paid all the money.
Ma'am, you need to direct questions, not a narrative answer. You'll have your opportunity. Ask your questions of the lieutenant.
And I did do an eviction on that. And then I turned around now, I'm on the second eviction. I told you, well, I'm taking care of it because I got to evict them because the ones that are left, you know, everybody's out of there. You feel me? And now we're on the part where they got processed and everything. And I told y'all that. Was you not told that?
No, well, after our very first meeting, during that meeting, when I asked you if you would evict Mr. Wilson, you made it clear that no, you would not evict him, because he told you that he would move out on his own. So I said, okay, well, if he doesn't move out, what are we going to do? And there was no answer to that. So the first time I was advised that you were going to evict him was June of last year, when Officer Frederick gave me this 3-day notice that you provided him with. However, I was not given any follow-up information, and the last information that I had as of July was that that process was never filed through the courts for the eviction. So no, I'm not aware at all that he's been evicted. And when we last spoke in January, and we again spoke about Mr. Wilson, he is the name still legally on the only lease that you have for that property. So I explained to you again that it was my strong recommendation before you come here today to this meeting that you serve him with the eviction while he's in jail, and you know exactly where he is. So I don't know if that's been done. I have not followed up with that.
I told you. I told the code enforcement they too, and I thought y'all was all in together because y'all stopped, came together the 2 times y'all came. And I told you that. Well, y'all was told that, y'all help me because I ain't used to this. Y'all were told that I was doing it. You feel me? I'm about nearly dead in my brain for going through this stuff because I'm going through other stuff with my kids, dealing with this, a lot of things. And I told y'all that, and I said, I'm doing whatever y'all tell me, just explain to me because I don't understand the theory and all these words. You have to explain to me and tell me, and I'll do it. So I said, when y'all told me I did something, I told y'all that I went to him, and because he was the head, and he said, all of that is taken care of, whatever, it ain't like that. He'll be moving out in January, and I've stated that also. But since
Ms. Humphrey, I'm going to stop you. I've asked you 3 times now. If you have questions for the lieutenant, you need to ask your questions. This is not your opportunity to give any narrative testimony.
Okay.
Do you have any questions of the lieutenant? You will have that opportunity. It's just farther down the way. The city has to
Well,
prove
I
its
did
case
tell
before you
them.
have to, the city has to prove its case before you have to respond to it. And the city's not completed its case yet, so,
Okay.
yeah. So do you have any other questions of the lieutenant?
Yes.
All right, what's the other question?
Twice that I was doing it, and I'm on my second one, and I'm trying to go all the way through where they were served, and I said, we're on the 5-day process, and I thought y'all was in together.
If I believed in January that he was being evicted, then I wouldn't have spent the time with Officer Frederick and myself explaining the eviction process. So our last meeting in January, no, I did not leave that meeting believing that any eviction paperwork had been started, because if it had been, I wouldn't have sat there and explained the process of how to evict him while he's in jail.
Yes, you gave me those papers that day, and I went to start on.
Ma'am, do you have a question?
Huh?
Do you have a question for her?
My
You'll
question
have
is,
time
I
to.
did do something about it. I did something about it.
Any other questions?
Yeah.
Okay, thank you.
No redirect.
Okay. Mr. Smith, do you have any other witnesses?
I do. I have final witness. Thank you, Lieutenant. At this time, I'm going to call the narcotics detective. And again, they're going to testify remotely. Detective, if you can hear me, please indicate.
You can swear in.
Detective, can you hear me?
I can hear you now.
Thank you.
Do you raise your right hand? Do you affirm to tell the truth throughout your entire testimony?
I do.
Detective, I'm calling you detective just to refer to you, but can you please state your title?
I am a narcotics detective with the Clearwater Police Department.
And how long have you been employed with the Clearwater Police Department?
I have been employed with the Clearwater Police Department for 19 years.
And in your capacity as a narcotics detective, do you have any formalized or specialized training and experience?
I have received training in narcotics investigations to include advanced training through the Drug Enforcement Administration for the sales, distribution, smuggling, and manufacturing of illegal substances.
Thank you. So in your capacity as a narcotics detective, are you familiar with the property at 1576 South Washington Avenue?
Yes, I am.
And that's in Clearwater, Florida, correct?
Yes, it is.
And how are you familiar with that property?
This property, I was the lead detective, and I debriefed an informant that had information regarding the illegal activity at the residence.
Okay, and did your discussions with that informant lead you to conduct investigations at the property?
Yes, it did. It led us to investigate the property several times.
Okay, I'm going to ask you about a couple of specific instances. Did you conduct undercover activity at the premises, and that's, again, 1576 South Washington Avenue on June 20th, 2019?
Yes, I was involved with an undercover narcotics investigation.
Excuse me, and could you please, in general terms, describe the investigation and the undercover informant, the activity that you conducted that evening? Did you meet with a confidential informant?
Yes, on the date in question, June 20th, I met with a confidential informant at a location. We discussed the activity that was going on, and we conducted a controlled buy at the residence where the informant went to the residence and made contact with Mr. William Wilson and purchased $40 worth of crack cocaine.
Okay, let me slow you down there.
Okay.
So a confidential informant, is it fair to say that a confidential informant is a citizen who agrees to assist the police anonymously in a criminal investigation?
Correct.
And they do that by providing you with information that assists you in the investigation?
Yes.
Okay, so specifically on June 20th, 2019, did the confidential informant indicate that they knew a place where they could purchase drugs?
Yes, the informant indicated they knew that they could purchase drugs from William Wilson at that address.
And did the confidential informant indicate to you that William Wilson resided at that address?
Yes.
Okay. Okay, so we've established that you've made contact with the confidential informant. Can you please describe the preparations that you would make that evening to engage that confidential informant?
Yes, the confidential informant meets with myself, the detectives. The confidential informant is searched prior to and after to make sure they don't have any illegal substances or any money on their person other than the money they are given, which will be City of Clearwater funds to use during the course of the investigation.
Okay, so you meet with the informant, you search them, you're satisfied that they have no illegal narcotics on their person, you're satisfied they have no money. At that point, you give them money to conduct an undercover controlled purchase, is that correct?
That is correct.
And so when you meet with the confidential informant and they conduct the purchase, are they under observation at all times?
Yes.
And that was, sorry.
Yes, they are under continual surveillance from the moment they leave the location with the detective until the moment they return to the detective.
Okay, and on this evening, they were under surveillance the entire time?
Yes.
Okay, and when they returned to your vehicle after presumably completing the sale, can you tell me what the confidential informant told you and what you said in response?
The confidential informant told me that he or she approached the property and told William Wilson that he or she wanted to purchase a 40, which was $40 in crack cocaine. The confidential informant gave the $40 to William Wilson, and William Wilson told a Terrell Bell to get the crack cocaine, and Terrell Bell went into a laundry room in the residence, retrieved the crack cocaine, and came back and gave it to the confidential informant.
So I think the board has heard the name the board has heard the name William Wilson before they heard Lieutenant Illich Haley speak about him as being the main problem. I don't think the board has heard about Terrell Bell. Was Terrell Bell known to you on June 20th, 2019?
Yes.
Okay, and who did you understand Terrell Bell to be?
I understood Terrell Bell to also be a resident of the address 1576 South Washington.
Okay, and so whether or not you knew prior to June 20th, 2019 that Terrell Bell was engaged in narcotics activity, your observations that night confirmed that both William Wilson and Terrell Bell were engaged in narcotics activity at the residence, at the premises?
Correct.
Okay, thank you. So the confidential informant obviously told you how the transaction went down, and then did the confidential informant turn over the narcotics that had been purchased?
Absolutely. The
Okay.
narcotics were given directly to the detective, which was myself.
Okay, and based on your training and experience as a narcotics detective, were you able to make a determination what the substance was at that time?
Based on my training and experience, it appeared to be crack cocaine, and then a presumptive test proved that it was, in fact, cocaine.
Okay, and after you identified it visually and you did a presumptive test, did you further send the substances to the Pinellas County Forensic Laboratory?
Yes.
And did the Pinellas County Forensic Laboratory return with a lab report?
Yes.
And what did they conclude?
Positive for cocaine.
Okay, thank you. In your opinion, based on your undercover operation and your observations on June 20th, 2019, what crimes were committed that evening at the premises?
Possession and sales. Possession of a controlled substance and sale of a controlled substance.
Okay, and the controlled substance we're talking about was cocaine?
Crack cocaine, correct.
And you understand that to be a controlled substance, and sale of that substance and possession of that substance, does that constitute a felony in the state of Florida?
Yes, it does.
Thank you. And has this case, has your case been referred to the state attorney?
Yes, it has.
Okay. Okay, that's all the questions I have for you on that date. I want to direct your attention to June 28th, 2019. Did you conduct any undercover activities at the premises on June 28th, 2019?
Yes.
Okay. And was this the same type of controlled purchase with the assistance of a confidential informant?
Yes, it was.
Okay. And I assume that you prepared the confidential informant the same way that you just testified you did on June 20th?
Yes, the confidential informant was also searched prior to and afterwards.
Okay. And on June 28th, the confidential informant indicated that they knew or believed that they could purchase illegal drugs from someone at 1576 South Washington?
Correct.
Okay. So what happened that evening when you met with and prepared the confidential informant? Were they under surveillance the entire time?
Yes.
And you observed them approach the property and presumably engaged in a narcotics transaction?
Yes, on this particular occasion, there were several people loitering out front, and the confidential informant asked where Chill was at. Chill is what they call Mr. Wilson.
Okay. And this is what the confidential informant told you when they got back to the meeting spot?
Yes, it is.
Okay. And at that time, did they indicate that they were able to successfully purchase narcotics?
Yes.
What did they purchase?
The confidential informant purchased $40 worth of crack cocaine.
Okay, and how did you determine that the substance, back up, that the confidential informant handed you a substance, correct?
Yes.
And they told you they believed it was cocaine?
The confidential informant handed me what appeared to be as crack cocaine, and again, it was also tested, and it tested positive, presumptive positive for cocaine, and it was also sent to the Pinellas County forensic for testing, and it tested positive again.
Thank you. And the lab report indicated that it was in fact cocaine?
Correct.
And again, cocaine is a possession or sale of cocaine is a felony in the state of Florida?
Yes, it is.
Okay. And that evening, what crimes were committed?
The same as before, possession and sales, both felonies. Possession of crack cocaine and the sale.
Thank you. And has this case been referred to the state attorney?
Yes, it has.
Okay, that's all the questions I have for you about June 28th. And finally, I want to turn your attention to July 9th. Did you again conduct undercover activities or an undercover investigation at 1576 South Washington Avenue?
Yes, sir.
Okay. And was this the same arrangement where you met with the confidential informant?
Yes, the same protocol.
And so the confidential informant was prepped, they were searched, and they were found not to have any illegal narcotics or money?
Correct.
And you gave them money with which to facilitate a purchase?
Correct.
They were under surveillance the entire time?
Yes.
And you observed them approach the property and engage in a purported illegal narcotics transaction?
Yes, the informant did as such.
Can you please tell me what you observed and what the confidential informant told you when they returned to the meeting spot?
Yes, the confidential informant again went to the property and approached Mr. Wilson, who is known as Chill, and asked to get a 40, which again is $40 worth of crack cocaine. It was reported that Mr. Wilson reached in his pocket and pulled out a sandwich bag that had what appeared to be as crack cocaine in it, and handed pieces of the crack cocaine to the confidential informant in exchange for the $40 of City of Clearwater funds.
And And the confidential informant subsequently handed you the the presumptive illegal substances, correct?
Yes.
And through your training and experience, were you able to identify?
Yes, through training and experience, it appeared to be crack cocaine.
And did you conduct a field test on the substance?
Yes, the substance was tested. It presumptive positive for cocaine, and with the others, it was sent to the Pinellas County Forensic Laboratory for testing, and those test results also showed positive for cocaine.
Thank you. And again, cocaine, possession of cocaine, sale of cocaine is a felony in the state of Florida?
That is correct.
And what crimes, in your opinion, were committed that evening?
The same, sales and possession.
Thank you. And has this case been referred to the state attorney?
Yes, sir, it has.
I don't have any more questions for you. Is there anything further you wanted to add?
I would just like to add that after these cases have been referred to the state attorney's office, and as earlier stated, Mr. Wilson has not been on property. However, as late of January of this year, we have an ongoing investigation for the sale and possession of a methamphetamine from that same property.
Okay, so if I understand what you're saying, even though it's your understanding that Mr. Wilson, who is the subject of your 3 investigations, was arrested, illegal narcotics activity has continued at the premises, correct?
That is correct.
Thank you.
You're welcome.
I don't have any further questions.
Ms. Humphrey, do you have any cross-examination? If so, step up here and ask your questions of the detective. Any questions of the detective? No? Okay, thank you.
I do not have any further witnesses or evidence for the board.
City rests.
City rests.
Madam Chair, it would be time now to bring Ms. Humphrey up, and she can present her testimony. We need to have her sworn in. Ma'am, if you want to step up here now is your opportunity. You need to be sworn in.
Do you affirm to tell the truth throughout your entire testimony?
Yes.
You get the opportunity to tell the board whatever you like and present any witnesses that you like.
I don't have nobody but the Lord. I just want to say, I'm the type, I want to do what's right. I'm not with no illegal substance and stuff like that. And I was telling them to explain to me, and when they came, I've been on it, you know what I'm saying? And mentally, I have been through a lot, you know, with the area. And I was doing the eviction. I don't have my other one. I must have dropped my other folder where it showed June 4th. You could go to the courthouse and see the records. And we was, you know, he was stating his part with the eviction where you have to have 5 days to reply or whatever. And he did that. And in the process, I was going through a lot because eviction take a long time. And the girl that does all that for me, she couldn't make it. She took care of my disabled daughter. But we got records showing, and it should be in the system because I spent my money. I paid the processor, all of that. But I was shot at. I don't know who I was shot at about. So mentally, I kind of got off course. But I was dealing with the city lady and asking her and the officer, Frederick, you know, when they come to me, what else I need to do. But on that one, I don't know what happened with that. But in the process, I've been doing the eviction again since January. It's just taking a little minute, and everybody knows about the eviction there. Because I told them I had to clear the house out. You feel me? They said, you know, everything was good, and they was trying to work with me. Everything they tell me that was a problem, I would talk to them, you know, and we've been just trying to get things together. And if you look in there, we're at the finish line. They already said we got 5 more days to respond because something wasn't notarized, so we had to do that part over. So we're waiting on the 5 days to respond again. And For as the code and all of that, I've been taking care of all of that, and I try to contact her to see if everything okay, and she would say, everything's looking good or whatever about the extra calls and the other stuff, only if somebody tell me. But then when I say it, I just felt like that was the police job if they doing something, because here, you know, I'm doing eviction. This is my second time. I don't even have money like that. The city has took my life really away, because all I did was hair and took care of foster kids. You know what I'm saying? I've been on my own since I was 15, so I don't understand a lot, but I know how to make money the right way. And I don't steal, I don't take nobody's stuff. You feel what I'm saying? So whatever problem it is, I'm willing to solve it. And maybe I didn't explain myself. I never said I would never evict him, because this is my second time. I don't have money to throw away. I don't use credit cards, everything, just to pay my little bills, because I was going at the teenagers that I had, you know, that it's just a lot. I can't even explain myself. I just got out of the doctor's. My blood pressure way up. I've been just stressed out because I'm trying to do the right thing, but they all three stood there, and they just had me just boohoo crying. I wanted to die. That's how bad it is, but it shouldn't be like that, because I don't want them to take my kids. So I'm trying to do what I can, and I don't want y'all to think I'm a bad person, and I'm with none of that illegal stuff. I just want to help, you know, with doing the right thing. I get rid of them and just get the right people, but I don't know. That all she was saying, some was true, but I did do something, and I stated to them that I did something. The city lady, I even went to the code place, and I spoke with whoever was there, but they said she wasn't there. I was trying to speak with whoever, but they wanted me to talk to her. She did come see me even last week, and I told her and the guy who she bought there that we owned. I told him what level we was on. I say, I'm just trying to do whatever y'all tell me to do. Even Officer Frederick, when they asked Chill to let the next door, all that whole group, the whole yard, yes, it was a mess. He took care of that whole family next door, and then I had Dr. Janelli, who's a millionaire, at me because they didn't pay him, but that was his house, but even though it was next door. So he said what he was going to do, call and do this, do that. And it's just people in the area, when you go to fighting or make one mad, they just make up stuff, they call. I mean, it's just sad. So don't think I'm not trying to do the right thing. I don't have money to pay y'all, but if y'all want me to do some work for y'all to get that money or whatever they said, because I don't even know what nuisance was, and I ain't trying to say I'm dumb, because that's, you know, I want to look presentable, like I got something, but I don't hardly have anything. And I just want to please the city, the code, the police, because I got plenty of detectives that call me and come see me. You feel me? About whatever, because I'm known. I've had 4 salons that I don't have none of that no more. I gave up everything I had 2012 because I had a little mental depression on a marriage that I had. But I'm just stating to y'all that I'm not no bad person. I do whatever I can. I'm good at my hands and not bad stuff. So that's all I want to say, because I don't explain myself well, but when I hurt and pain, I can say what I'm feeling. And I'm very hurt, and, you know, and I understand. I don't understand everything. I hear y'all saying about the drugs. I can't say I seen it. I'm just going by what y'all saying, but I'm getting them out of there. You feel what I'm saying? That's all I can do. So, I don't know.
Cross-examination?
I have one question. Ms. Humphrey, you've testified that you did file an eviction against Mr. Wilson.
Yes, I have the paper right now.
Do you have the final order?
Huh?
Do you have the
For the
final?
one we're doing now, the final, we on that 5 day, the process already been out there. And then you have 5 days, we on that last end part. Then the police, you have to pay the sheriff to come.
Could you produce what documentation you have?
What you talking about now?
Sure, yeah, the records. Did you bring any records today that substantiate that you tried to evict Mr. Wilson?
Yes, for June, I thought that other folder must have was left on tape, because we just grabbed it. I said, I want to be on time. And she grabbed it, so I just got out of the doctor's. But the lady said, make sure you don't miss it. I said, I ain't, because I'm not trying to hide nothing. But I was looking, this is the one from June, but you can see it went all the way through to June the 4th, 2019.
Yeah, there should be an order from a judge or from the court, and it should have the court's caption at the top. So if you have that document, whatever you have,
Yeah.
just please place it on the Elmo.
I had another folder that the one we're doing now. This is the first one. That's why I was telling her I did do something, but a lot has happened. The city, a lot has happened, and I'm trying to get out of this and get whatever situated myself. You feel me? Because this is a lot of stress.
I don't have any further questions.
Thank you, Ms. Humphrey. Do you have any other witnesses that you would like to present?
Well, Miles, he gone. That was your son that stayed there. But he just must have walked out. I don't know. But I didn't bring them. They texted and said he wanted to be here. I said, that's fine if they let you. But my daughter's here. She just started staying with me, my ex-husband's daughter, and God put her back with me, and I told her I want her to teach me some stuff. I had a lot, and it's only God blessed me with, but I just know if you talk to me or tell me something, I'll do it. You feel what I'm saying? And I'm not that smart.
Thank you.
Say something for me? Yeah, but I'm not no drug person, and officer friendly. I didn't know he was the same guy from many years ago, but he made me feel bad with the police system, but he did get it right with me. You know, I felt bad because I was taking care of the teenagers, and some of them had came from down there. You know, I just try to help people. That's how I got involved with, you know, and I paid for some of them to enroll in school, this and that and the other. You know, when I had the funds, it wasn't a lot. So I was motivated to go out and take them to the boys thing at the 49th Street. And the people had good things, but he broke me down so bad in front of the kids to say he's going to keep messing with me till he get me kicked out. And I was like, wow. You know, and how he felt about me, he stated it in front of the people. And I was like, I'm not that type of person. So I just felt like the police went down with me. I felt like the city wasn't down with me. I'd been doing hair. I moved back here in 1994 to do a change because I was going through a marriage. That's why I was Solomon. And that marriage got me here. So I came to do hair, take care of kids. And this has been since 2008. And I have this and I put it in my salon. I've been doing hair at my home next door to 1576. I only got that property for parking. You know, for the Ford parking they allowed me to do. And I asked the city, could I go there? And I just think they've been at me. That's what I think, because I felt like if children selling drugs and they telling me whatever, arrest them. Take them to jail. Don't put that on me. My life was threatened. The car was shot at twice that I was in. Mentally, I'm still messed up. I just lost my mom, which is my auntie, stayed 2 houses over from me. Y'all don't even know. It's a lot. And everything was pretty much signed. And when I moved there, the house is big now, and it took me like a year, because I had a little something then. Only for them now get in there and then turn me down, but it says payment only. And I didn't want to get nobody fired or in trouble, so I just left it alone. And the one guy left the job. They left, I was crying and everything. They said, well, she should know. I didn't understand. I said, I do everything y'all tell me. And before I make a move, I ask them. And right now, this is all I know, doing hair and taking care of kids. But I could do other stuff, but that's all I've been doing. And I thought the city didn't care for me, but the ones that was in there, they was pretty good. But she's not there no more. And that's all I do. And I try to get permits, and I might be in trouble, but I tell them myself. I did me a little bathroom, whatever they want to do, because I said I didn't want them to give me a complaint. I pay permits for everything, but I didn't do that because I thought they was going to take that away from me. They already took. But my daughter's disabled, and I do things, hair for free and everything, to help people. I'm a minister for the word, and I understand a little because the Lord gave it to me, but for us, the stuff like school stuff, I don't really know. But if y'all could tell me, I mean, I'll do whatever y'all want me to do, but I don't have a lot of money. I got a few dollars, and I got some credit cards. So I did bankrupt, so.
Thank you. So now would be the opportunity for the city to make any closing arguments that they wanted to make, and then Ms. Humphrey would have the same opportunity. Okay.
Thank you. Board, this board has the ability to hear these cases and And the board's powers are laid out in Chapter 20 of our ordinances, and those are authorized by state statute. And what I have to prove, what the city has to prove, is enumerated at 20.025C. And that says that on more than 2 occasions within a 6-month period, this property has been the site of the unlawful sale, delivery, manufacture, or cultivation of any controlled substance. So today you heard, within a 6-month period, there were 3 separate sales at this property. So the city, I humbly submit that the city has satisfied the burden. So now we turn to the powers that the board has. But before I get to that, we heard from Ms. Humphrey, and I asked Ms. Humphrey one question. I said, what evidence do you have that you evicted Mr. Wilson? I gave her the opportunity to place the documents on the Elmo. For whatever reason, she did nothing. So I would submit to you that the testimony of Lieutenant Ilge Haley is uncontroverted. She apparently has a file folder, and she decided not to show the board what she has, and I would submit that's because she didn't actually evict Mr. Wilson. And that's the only explanation that the board heard. Okay, Lieutenant Ilge Haley laid out several things that she could easily have done, and with the exception of adding the exterior lighting, these are virtually low-cost things to do. The biggest thing is have a written rental agreement. I mean, that's just, even if you don't have a nuisance property where drug activity is going on, if you're renting a property, you need to have you need to protect yourself. She can't even do that. The lieutenant asked her to put in that clause. That didn't happen. Require the tenants to show photographic identification. That didn't happen. The only thing that's going to cost her any money would be to do a background check. How much does that cost? $100. Again, she's protecting herself, and she hasn't done any of these things.
I did.
So the other. Sorry, I was interrupted. I'm hearing someone in the audience, and it interrupted my train of thought. But I think I'd made that point. I think the board heard me that the things that Lieutenant Ilge Haley asked the owner to do were low-cost things that could have gone a long way to mitigating the activity. She didn't do anything. She provided no evidence that she made any efforts to evict this individual. And in fact, the only reason this person is not there anymore is because he was arrested on unrelated matters. And it doesn't matter because, as you heard the narcotics detective testify, the activity has continued in his absence. So someone else has stepped into his shoes, and that's the environment that she has allowed to happen at her property. And again, this is almost a year that we've been dealing with this property. Lieutenant Ilge Haley testified that she began working with the owner back in April. It's February, so what is that? I'm no expert in math. That's 10 months. And at this time, I will tell the board. I will show a PowerPoint of what recommendations I'm making. Have access to this. apologize. I was trying to log into the computer here with the default login, and it's not accepting it. It's going to take just a minute for this to log in. But I'll go ahead and start telling the board what the city's recommendation is, and then once it boots up, I can very quickly put that on the screen for you. First of all, the city would ask that the board declare 1576 South Washington unlawful public nuisance, and the board has that authority per local ordinance 20.0211B. Secondly, we'd like the board to order discontinuation of the nuisance drug activity per city code 20.0211C1. Third, we would ask the board to prohibit the owner from renting to Terrell Bell or William Wilson, and that's per city code 20.0211C3, begin eviction proceedings in the event that they have not already been begun. And we would ask that that be done whether or not these individuals are incarcerated, because they may have intent to return to the property. Fourth, we would ask that the mitigation strategies that Lieutenant Illich Haley testified, that the board order that those things be done. And once again, that is have a written rental agreement, and the rental agreement needs to contain verbiage stating that any illegal criminal activity will lead to an immediate eviction. Require tenants to show photographic identification, attach a copy of their photograph of that identification to the lease. We want the owner to complete background checks on future tenants. We want the owner to add exterior lighting. Bear with me 1 minute. I'm going to pop in this USB, and you won't have to remember everything I'm saying. All right. Okay, so as I've discussed already, number one, declare it public nuisance. Number two, please stop using drugs. Please stop allowing drugs activity to happen at your property. Number three, prohibit them from renting to those named individuals. And number four, again, we're asking the board to adopt the mitigation strategies that Lieutenant Illich Haley testified. Exterior lighting, improve the exterior appearance, and the last slide. So we're asking that the board impose a fine of $750, and the way that breaks down is $250 per day, and that is $250 for the 3 days that you heard there was proven illegal activity at the premises, June 20th, June 28th, and July 9th. We're also asking the board to award reasonable investigative costs, and you heard the narcotics sergeant testify to that, and again, that total was $823.22, and that is the cost of the police investigation. And finally, the city is asking that the board award reasonable costs associated with this hearing, and that includes the attorney's fees, cost of recording the order, investigative costs, and that totals $587.30. Thank you.
Ms. Humphrey, the city has presented its case and made an oral argument at the end. Now is your opportunity to address the board one last time to go over the testimony that you provided or any of the evidence that has been submitted. If you'd like, you can do that now.
All I see is those three, but the fifth one, so 3 days, 3 days, I just feel like I've been doing that, and I spent that out for this eviction, and I could have somebody bring that up, but I couldn't go out and get on the phone. I must have left it on the table, I know I ain't got it right now, but I thought I did. It's the old, first eviction I was trying to do until I got shot at. Y'all didn't have to do an investigation if y'all already knew that they did that. Why would y'all just take them to jail? I just feel like they should have took them to jail. Don't leave that on me. I want to live, take care of my kids. So I don't feel like that's all my fault that I wasn't doing that. If y'all could go in the record, y'all will see that I did do that. And it's almost over with. I barely had the money for the processor. This for y'all time, I understand, but I need to know how long I have to pay this stuff, because I don't got that just like that, adding that up. I still got to pay my mortgage, over $1,000. Pay light bill, phone bill, cable, all that. I just think if y'all could work with me a little bit, I understand, because I should have did whatever, and I deserve to get that whooping. But if y'all could work with the figures a little better, I mean, I'll do it, and I'm still working on the process, and I'll show it to you. If I can send it to you in the mail, ain't no date's gonna be changed. And like I told her last week, we was on the 5-day thing. So that's all I can say.
Thank you.
I'm quitting.
Madam Chair, now that all the testimony and evidence is presented to you, the case is before you. You can handle it in one of two ways. You can, address whether or not you want to declare the property an unlawful public nuisance in one motion, and you could consider adopting the recommendations made by the city in a second motion, or you can do it all at once. If you believe that the city has failed to meet its burden of proof, then you would just dismiss the complaint. It would be a motion to dismiss the complaint. So those are kind of your options at this point.
For the board, I would move to handle the first three requests from the city together and treat the fourth request separately. So specifically, I would move to declare the property an unlawful public nuisance, to order the discontinuation of the nuisance drug activity per the city code, and to prohibit the owner from renting any unit to William Wilson or Terrell Bell, and begin eviction proceedings in the event those named individuals still reside or intend to return to their premises. As for the fourth request, mitigation, I do have some questions about that for the board, so that's why I'm moving this way. Does anyone second the motion?
I'll second adopting those three.
Okay, and for discussion, does anyone have anything to say regarding the motion, or?
Well, I have a lot to say. I would like to say that I think it's ridiculous that we're sitting here and wasting numerous people's time with these allegations that have been clearly met the burden of proof. And I don't believe for 1 second that Mrs. Solomon doesn't absolutely know what's going on at her property. And actually, it's properties. And yet she stands before this council and is talking about having a possibility of raising money to possibly pay her fine, whereas she's owner of several properties, and by her own admittance does hair for a living. And I just don't understand that you can stand before this board and say that you have attempted to do what these police officers have asked you to do when really nothing's been done. Everybody's sugarcoating the fact that you haven't done anything. I said, but I, for one, agree with the case of the city, and I can't believe that you can stand here and talk about what a good person you are when we have another narcotics detective telling us that this is all starting all over again. So like I said, I agree that at the very least, the first three should be immediately adopted and then go on to the fines, which I think are a gift. But that's my statement.
Any other further discussion about the motion to adopt the first three recommendations from the city? No? We'll take a vote. All in favor?
Aye.
Any opposed? The motion carries. Since I kind of indicated I wanted to take the fourth one separately, I move to implement all of the mitigation strategies that the city has recommended, minus the background screening for future tenants. And if anyone wants to second that, they can.
I'll second that.
Okay. So I'll offer a comment first. The reason I just feel it's probably more of a burden on the property owner, and I do understand that she's been a burden to the city as well, because this isn't about whether you're a good person, it's about your property and how it's affecting the citizens of our community. My concern with the background screenings is that I don't see any, I'm in human resources, so I background screen people for a living, and we have a checklist for what would be accepted or what would be acceptable crimes on a rap sheet that we find through background screening. There's no specifics about finances of the potential tenants, so you don't know if that screening includes a financial screen. It's just a little vague for me, and it seems burdensome knowing the area and the type of tenants that you would probably attract to that area. Having lived in that neighborhood myself, the one time I tried to rent an apartment nearby, I paid $40 for a background screen, knowing I'd clear it, and they took my money and I couldn't rent the apartment. They said I failed. So it just feels like a technique that, in this particular situation, I'm not sure it's worthwhile. Does anyone else have any comment? Okay, so the motion on the table is to implement all of the city's recommendations, which would include having a written rental agreement with verbiage stating that any illegal criminal activity will lead to immediate eviction or the start of an eviction process. Require tenants to show their photographic identification and attach a copy or photograph of the identification to the lease. Add exterior lighting to the property and improve outside appearance, which might include removing rubbish and taking vehicles off the property. All in favor of that motion?
Aye.
None opposed? Motion carries.
Okay, so we've got to address the other items then, 5, 6, and 7, the requests that have been made by the city.
Okay. So I'll just take them separately. I would move to impose the fine of $750, which is $250 times 3 days for each day the nuisance activity occurred on the property, which was June 20th, June 28th, and July 9th of 2019. Does anyone second the motion?
I second that.
Any discussion? Okay, all in favor? Any opposed? None. No opposed. Motion carries. For recommendation number 6, I would move to award reasonable costs associated with the investigation. The cost in the amount of $823.22 per the narcotics sergeant's testimony. Anyone second?
I'll second that.
I have a question.
Okay, discussion?
Was there any testimony as to how much of that $823 was police investigation of what was going on at the property as opposed to preparation for this
And actually, no, the last time we did consider a motion like this in our previous history with the board, we did see a breakdown of those charges. And Mr. Smith, we don't have a breakdown.
The city can certainly provide that breakdown.
Okay.
I can provide it for you right now orally if you'd like.
Will we accept it orally? We okay with that?
Be better to hear it orally than not at all.
I agree. If you don't mind.
Okay, so for the case on June 20th, 2019, the total investigative costs were $254.98. And the way that breaks down, $4 for one detective at $29.14 an hour. That's $116.56. 1 hour for a detective, again, $29.14 for a total of $29.14. A third detective at $29.14 an hour for a total of $29.14. And a fourth detective, also at the same hourly rate, for a total of $29.14 1 hour. That's the personnel cost. Personnel total was $203.98. Evidence submission cost is included in that overall total, and that there was one item submitted. There was the narcotics. That was $11 to the sheriff. And then finally, the money that was used to purchase to facilitate the buy, that was $40, and so that's how you get the $254.98. Okay, for the next case, this was on June 28th, 2019. So again, you have 1, 2, 3, 4, 5 detectives total that evening. One detective for 4 hours, the remaining 4 for 1 hour, again at that hourly rate of $29.14 an hour. That totals up to $233.12. That's for the personnel costs for the detectives. Evidence submission costs of $11 and the $40 expended to facilitate the purchase. And again, that total was $284.12. Finally, for the July 9th, it's the same total, $284.12. And it's the exact same breakdown. 5 detectives, the bulk of it is the personnel cost at $233.12, $11 submission, $40 funds used to facilitate the purchase.
Thank you.
Yep.
Any further questions?
Discussion?
Yeah, do we have discussion?
I feel that it's really not an appropriate remedy in trying to have a nuisance abatement to charge the defendant with the cost of the police enforcement of a drug operation. Why should she be paying for the cost of the purchase of the narcotics? We know that she shouldn't have let all this stuff go on. And I'm certainly going to be in favor of the next item of cost, which deals with this proceeding. But I object to imposing the cost of the police investigation.
So to play devil's advocate to that, I would say that the code allows us to do it, first and foremost. And secondly, I would argue that the spirit of the charter and why this particular code was adopted is basically that these problems would not exist if in fact this property owner was responsible. However, we know that the police are doing that in the course of doing business every day. So I see your point. I'm just trying to put the other side out there that in this particular instance, these investigations wouldn't have had to have been done. I'd also like to point out that on the background information, there were 5 additional, 5 additional arrests that she's not being charged for. or, sorry, not arrests, but we served a search warrant and had 4 other undercover activities that are not included in that total.
7.
And those all occurred before we made initial contact. So in that case, I guess I would argue when you don't listen to the lieutenant or you don't engage in the process, then any further investigation that we do, I don't know, that's just my mind. I'm kind of the mind that I'm okay with that. So shall we put the motion to a vote to award reasonable costs associated with the investigation of $823.22 for the sergeant? All in favor?
Aye.
All opposed? So we have a vote of 4-2, the motion carries. So the last recommendation by the city, I would move to award reasonable costs associated with the hearing, the attorney's fees, the investigative costs, and the cost of the recording order of $587.30 per the clerk. I'm sorry? Can someone second the motion?
I'll second the motion.
Okay, sorry, I didn't hear you. Should we ask for a breakdown of that? Is anyone interested?
No.
No? Any other discussion? Okay, all in favor?
Aye.
None opposed? Motion carries.
Okay, so at this point then, we'll take the information and the motions that were made tonight and we'll place them in a written order. They'll have the chair sign that order. That will probably be done within the next 10 days or so, just so that you all know what the process is. It'll be provided to you as well, Mrs. Humphrey, and then you'll be obligated to comply with the terms of it. If you have any questions after today's hearing, you can talk to Attorney Smith after the hearing, and he'll be happy to hopefully answer your questions. So now we can move on to the next item on the agenda, Madam Chair.
Yes, we can. We have case number 2020-02, the City of Clearwater versus, is it DVOM LLC?
Is Mr. Patel present? Mr. Patel is the owner of DVOM LLC. Since he's not present, I'm going to ask that the board continue this case. It'll be heard at a later date. I have concerns holding the hearing in his absence.
Understood. Per that recommendation, I'll move to postpone agenda item 4.3, case number 2020-02, City of Clearwater versus DVOM LLC, to our next meeting. Can I get a second?
Did he know about this?
I'm sorry?
Did he know? Was he?
I can't, no, I don't think he knew.
Before we discuss, can someone second?
I'll say.
Okay, yeah, and you don't think he knew?
I can't prove that he knew.
Okay,
Due process requires that he have notice of the hearing. If we did know that he was properly served, then we could go on with the hearing without him being here. I think it's the appropriate thing to do to be on the safe side and not go forward with the hearing. So you have a motion on the floor.
okay, so all in favor to move 4.3 to our next meeting?
Aye.
No opposed, motion carries. And there is no other business on the table, so this meeting of the Nuisance Abatement Board is adjourned. Thank you for your time.